All right. So I want to start this. I want to give you a couple of minutes just to go over who you are and just some little details about you for those who will be watching this later, just so they remember who you are. So you can start when you're ready.
All right. Well, my name is Brian Cain, and I'm an attorney in Conroe, Texas. And with Griffin & Cain, I've been here since 2009. Well, the firm was officially launched in 2010. Before that, I was just working with my now partner, Mike Griffin. Phone. I'm a fourth generation Texan, native to the Houston area, and wife to my husband and my wife, Katie, is for 17 years. I've got two children, Eleanor, who's 5, and Abigail, who's 9. They take up obviously a lot of our time while I'm campaigning. I still manage to get them up in the morning, get them on the bus, and get them to bed every night, which is very difficult managing that schedule. But just about every night I'm able to maintain that kind of schedule. I'm running for Judge, County Court at Law number 1. A lot of the reason I think that I'm a good candidate for Judge, the best candidate for that position, is based on my background. I didn't go to law school right away. I spent a little time thinking about doing some other things. I started, first of all, thinking I was going to be an Episcopal priest. So I mentored in that while I was finishing up my time at UT, getting my undergrad. I got my undergrad in history and religious studies. It was so far into that end of things that I actually, my foreign language credit was ancient Greek. Very useful these days, obviously, but it would have been very useful had I continued on that path. But the mentoring process brought me to the decision that wasn't for me. So then after some time, I went and got a master's in history, thinking I would be a historian and professor. So like I said, I went down a couple different paths before going to law school. And why I bring that up is I'm a contemplative person. I make decisions, making sure I've got all the facts, as it were. That's my temperament. That's who I am in my heart and at the core soul of myself. And that's the kind of temperament that I bring to the bench. It's the kind of temperament I bring to my law practice, first of all, right now. And I found that to be very helpful. It makes me detail oriented. It means that also, as my journey to this point means I'm very empathetic to people, and I'm able to find their problems, their real problems. Sometimes they come in and say, "This is my problem." I go, "Well, that's not your real problem. This is your real problem." So as a lawyer, issue spotting is the number one thing. If you can't spot the issue, you can't fix the issue. And like I said, that's the temperament I'm going to bring to the bench should I win this race. It's also the temperament that I bring, that I brought to just making this decision to run. I enjoy being a partner at this law firm. I enjoy the practice of law. I enjoy the camaraderie at this law firm. It would be bittersweet leaving the law firm. But at the same time, the process I went through, whether or not I should run for this race, is the same process that took me years to decide the practice of law is what I wanted to do. So that's in a nutshell kind of how I am where I am right now.
Right. So like you said, you took a couple of different career paths before ultimately deciding on law. So what was the ultimate factor that made you go into law?
What was the ultimate factor? Yeah, cut out just a little bit there. So while I was, the decision to go to law school was made while I was finishing my master's. I completed it, even though I knew I was going to go on and do something other than law school. I had another semester left. I still had to do my thesis, but I knew I was going on to law school from there. In fact, I applied and took the LSAT and did all the necessary steps while I was finishing up my master's thesis. So the decision was already made about halfway through pursuing my master's. A couple things pushed me that way. First of all, I realized that continuing on and getting a doctorate and becoming a professor and historian was going to probably lead me to, not economic hardship, but I wanted a family, and I wanted to be able to support a family well, and I didn't want to be in a position to struggle. So that was part of it. The other part of it is as I was taking my classes, I was researching my thesis. Some things in my research just caught my eye, and I thought, you know what? I'm making arguments here. This is not necessarily a bad thing. And so I started talking with some friends and some colleagues, and they said, well, I mean, you know, you're concerned about your career path. You think that it's a hard road, and that the percentages of people who make it in that path are actually very low. You might want to consider law. And so that's what started me on, you know, thinking about going to law school as opposed to continuing on.
So how do you feel that I get, you kind of already addressed this, but you spent a lot of time in to become a pastor. Is that what it was?
Episcopal priest. So
Priest.
yeah.
So and then into history and then law, and those are professions which require a lot of studying, a lot of understanding, and in some cases the ability to argue, as you just said, from an attorney perspective. So how do you think that makes you the most qualified for the position?
Well, and a judge, as an attorney, you got to research your client's issue, right? And sometimes, I mean, in an average year, you probably have 100 to 130 cases that you can either open and close, or at least work substantially on. In my line, at least, where I do a lot of criminal defense and family. You know, like I said, 100 to 130 cases, you got a lot you're going through, but a lot of them are the same. So there's not a lot of research that needs to be done for them. You do have several a year. So, you know, 3 or 4 dozen that you do need to do some research. You look at it and you go, well, this is slightly unique. Let's see whether or not there's this particular fact pattern requires something different than the knowledge that's in my head right at this moment. So we need to do some research. Now, as an attorney, you've got to do that research. As a judge, you're going to see a couple thousand cases a year. So the chances that you're going to be doing research are obviously a lot higher. And that's something that I have substantial background doing, not just in law school and learning how to do legal research, which we all have to do, but and broad-based research, the kind of research that that I did to create my master's thesis. You know, it was a 100-page document. It's not something super impressive or super long, but it was still something that I had to create from scratch, from source material, not just going up, look up cases and come up with a brief with a set of facts that are given to me, which is what you do in law school, or what you do with your clients' cases. This is something I had to create a topic for myself with a little nudging from obviously the professors on my panel as to, you know, well, that topic might be too broad. Maybe they'll narrow it down a little bit. Those are the kinds of like I said, nudgings you get, kind of direction you get. Make sure you don't bite off, you know, more than you can chew in a thesis statement. You know, some people come in, oh, I'm going to write about World War II. Well, that's a gigantic area of study, you know, or the 30 Years' War or whatever. My thesis was on the election of John Tower in 1961. He took over. He was the first Republican to win statewide office in the state of Texas since Reconstruction ended. And he got elected to Lyndon Johnson's unexpired term, because Lyndon Johnson was able to run as the vice president on JFK's ticket and be reelected to the Senate at the same time. That was permissible. I don't think we see that much anymore, but so Lyndon Johnson's seat on the Senate had to be filled, and so the next year they had a special election, and John Tower won that one. So that my thesis was about his actual campaign. That research took me to Georgetown, where his documents are. So I was able to get all of the materials from his entire time. I could have looked at it all the way up to the end of his career in the 80s and 90s, but you know, that's not necessary. It was really just about 1961, 1960, 1961 leading up to it. And then some of the things that he wrote afterwards to add a little color as to why he was running, what he was about, and those types of things. So it's looking at source material, not taking, you know, looking at, like as you do in undergrad, where you're looking at other people's monographs, other people's work, and summarizing it, or maybe trying to put a slightly new color on things. This is what a historian does: take source material and create an argument of your own. Right. So that's the kind of thing that I have a more in-depth level of research than the average lawyer does, because I have that scholastic background. And I didn't go on to get a doctorate, so I'm not trying to say that, but you know, you're in training when you're going through your master's to become an historian, and that's the first big step. And then obviously your doctorate's another 2 or 3 years, and then you need your dissertation.
Right. So Montgomery County has been and is still experiencing a wide boom of growth. And with that growth comes increased crime rates, which have already begun realizing. So what are your plans to help manage the growth in cases that you will undoubtedly see at the county court level going forward?
So first, I want to speak to those numbers. I've been researching the numbers for County Court 1. I haven't looked in depth as to County Court 4 and County Court 5, our other criminal cases, but I do know their current case counts, at least as of the most recently reported statistics. Right now, County Court 1 is actually in the best position, case count wise. It's well under 2,000. The other two courts are a few hundred over 2,000. But if you look at the broad trends, and I think your question is valid, I'm not trying to say it isn't, but I just wanted to put a little background to it. If you look at the trends of the number of the case counts in these courts, they've actually gone down over the last several years because of various things that the judges and the sheriff and the DA have done as far as managing these dockets. So we're actually in a good position right now to absorb a lot of that growth for a little bit longer. Obviously, you grow. The growth that we've seen in the last 10 years continues for another 10 years. There will probably be a push for another court somewhere in those 10 years, not necessarily right away. But like I said, there's a lot of room to absorb new growth. And the way you do that is to make sure that you are available as a judge to do trials. When you set cases for trials and you tell the state and defense, we're going to have trial settings on Mondays and Wednesdays, and we're going to have those trials. We're going to set up at least 3, sometimes up to 6 or 8 that are going to be ready to go on those Mondays and Wednesdays. When you have them, when you tell them, you hold their feet to the fire and say, no, we're not going to continue it just because you have some semi-valid reason. This thing's been continued twice already. We need to put these things to trial. And when they go to trial, you know what happens? Most of them plead. Mm-hmm. So that's how you move cases, is you have them on a trial docket as quickly as possible, so that if there's going to be a scheduling issue, then we deal with that at the first time that it comes up for what's called a call docket, which is a docket right before a trial. And if you've ever gone to a call docket, the one in Judge Watson's court right now is pretty fun. You get to see all the lawyers that have cases pending for the next 10 days from then or so, and it's usually pretty fun. We're all kind of waiting to see what excuses come up. And of course, sometimes it's the state, sometimes it's defense that wants them. Defense sometimes wants to push things to trial. The state's usually ready, but they have their own issues. If they have a witness, like an officer who's in training or has a vacation, they're going to want some time, obviously, because they can't go forward on a DWI trial when there's no officer available, or the officer who did the arrest. You got to have that specific person. So you put them on a trial docket at a quick pace, and then that way, when the inevitable scheduling issues come up, it's not going to delay it too long down the road. Now, some of these cases, we'll just say this real quick. Some of these DWIs, especially when blood is a part of the blood alcohol content is a part of the evidence, they can take longer because you have expert witnesses, and you also have the state of Texas DPS office has to turn over evidence, and that takes time. So there are some things that are out of the state's control, out of the court's control. But if you get the lawyers to come to court often enough to make sure that they're on top of those issues, we can obviate those delays as much as possible. Nothing's going to be perfect. Nothing's going to be, I'm going to do exactly this. But you make sure that the attorneys come to court often. You have frequent trial settings, so that somebody that wants to go to trial, when that's ready, we can do them. And you keep the courtroom open for settings so that if people want to do it. I mean, I've had a situation where I wanted to do a plea, and my client's like, let's get it over with. And we can't get into a courtroom for whatever reason. So it's about access, and it's about holding people accountable for the fact that they're working on these cases, so that when the inevitable, like I said, scheduling issues come up, they're going to, that you're not delaying things so much when they do come up, because you just have to be ready for them.
So you would place a priority in the dockets on trials? Absolutely.
That's how you get things done. Just coming to court, for people who don't go to court, I'll just say this real quick. Usually there's a 3 or 4 settings, and then you'll have a trial setting. So you'll have an arraignment setting, which looks just like the next setting. We call it a pretrial setting, or you call it a pretrial determination setting. It's just 80 people sitting in a courtroom waiting for their lawyer to show up, talk to the state, maybe work out a deal, maybe some evidence needs to be exchanged, maybe some conversation needs to happen, and it's just a setting. You get another piece of paper with another date, and you leave. So having it set for trial, though, now the judge is saying, well, I'm expecting y'all to start calling witnesses after we pick a jury. So there's a heightened, obviously, level of readiness that both sides are going to have to get to before that setting. And it also pushes defendants to make a decision. We've been resetting this. Is that because you want to have a trial, or is that just because you just don't want to do that plea that you think you're going to end up doing anyway? Most cases plead guilty. We can only do so many trials in a year. If we did 2 trials a week in every court, it's still only let's say 50. So 100 times 3 courts, 300 trials. I've already told you how many cases there are. So we don't do that many trials at the end of the day. If each court does 30, that would be really good. But having the trial settings pushes the pleas, and that's what gets your case counts down, and that will allow you to absorb more of this growth that you're talking about that is definitely coming our way.
So how do you feel the pandemic impacted not just court operations, but the handling of the cases? And are any of those changes, do you feel, here to stay going forward?
Probably not. A lot of the cases that were lower level, there was a discount as to the pleas, to be honest. They had to move these cases. And that was, like I said, if you're not going to have a trial and you have an offer that a defendant doesn't want to take, it's not going to get taken. And like I said, the case counts are still low. They're a little bit higher than the pandemic, but not much. So they were handled well. So things happen in crises that we just went through that you can't really apply going forward. Now, what did happen was federal grant money allowed us to deck out our courtrooms with Zoom equipment, which I do want to use going forward. And you can't have trials with jurors sitting at home and things like that, but expert witnesses can appear via Zoom, which can help with those scheduling issues I was talking about. You can have dockets leading up to trial, where this is another thing that's the part of the sausage that people don't see. Attorneys in my line of work in multiple counties, some of them all over the place, and some of them it gets to be difficult to make sure you don't put yourself in 2 counties 100 miles apart on the same day at the same time. It happens quite often. So that's a way to prevent that from slowing down court operations. I don't know how many times I've been in a court and, Mr. So-and-so or Ms. So-and-so is not there because, they said they're in Fort Bend this morning. Well, okay, go in the hallway, pull out your phone, talk to me. That's how I want to use Zoom to keep things moving along. You got a defendant there who we might just reset ourselves under normal circumstances, but if the attorney can get on Zoom, maybe something can get done with that case that day.
So if elected, what are the day one items that you want to address?
So day one, I'm going to have to look at how the scheduling is done, and I'm probably going to look at some changes in maybe what we call the settings, the length of period of time between settings, coming up with a plan for what is an appropriate, and I'll have it before I take office, but the exact amount of time I want to have from the day that a defendant shows up for his first court setting to when his first trial setting is going to be. You need to pick, you need to look at the numbers and make sure that there's an appropriate time. And I want the first setting to have that trial setting on it. That's not always the case. Some of these courts do them, some of them don't. But I would like to have that first trial setting on there. Like I said, to prevent the scheduling issues from slowing us down, if you have a trial setting on there, well, now you've been on notice for a long, long time about that problem. And maybe we can actually do your trial on that first setting. So that's the number one thing that I would look to do. And the number two thing I would look to do would be what I talked about with Zoom and teleconferencing, is make some policies as to, when attorneys can and can't use that. Make sure that it's well known that my policies do include appearing that way, and talking with the state of Texas about ways to make it possible to get plea paperwork done off docket so that an attorney can appear on Zoom with the paperwork already filled out. These are things that we have done for defendants in jail. And we did these, when the pandemic was at its height. We didn't bring inmates over. We Zoom conference with them at the jail, and we would send paperwork to them and all of that. Well, I'm not talking about send it to the jail. I'm talking about ways that, the attorney can get the paperwork, get with the defendant in their office, and then file it. And then, maybe not the defendant, but the attorney can be, like I said, in another county if he or she needs to be, and get that plea done. So those are some of my priorities day one.
Mm-hmm. Is there anything else in particular you would like people to know about your campaign of the court?
Well, I would like to say that I am not a natural extrovert. I'm kind of gone over beating the dead horse of how bookish I am, how much I can stick my nose in a book and withdraw from crowds. I was not the person that was the life of the party. I was the guy in the corner would talk with the people that I already knew. You can't campaign that way, obviously, and so I've broken out of that. And I will say that it's been exciting to learn that I can actually do that kind of thing. So that's just a little tidbit about me. I'm not going to withdraw to being what I was before. I'm enjoying what I'm doing on the campaign trail, and no matter how this comes out, as you should with anything, you should learn something more about yourself and learn to make the best of everything. And this is just another step forward in my life.
All right. Thank you very much, Mr. Cain, for your time today.
All right. Thank you.
Have a great afternoon.
You too. Bye.